Good morning, everybody.
Good morning. How are you, Anna?
I'm well, thank you. And, and how are you?
I'm fine. I'm glad it's Friday, but it's
Yeah, anytime
everything's
this
fine.
off.
All right, good morning, everybody. I have 9 o'clock, so let's make just a couple more in the waiting room here.
Good morning, Hans,
Good morning.
and everybody.
All right, Madam Court Reporter, are you all ready to begin? Let's go
Mr.
on.
Hearing Examiner, I have a preliminary matter I wanted to address, but I could bring it up at our first break if that would be preferable.
I'm gonna do housekeeping matters in 1 minute here. So let me just start the record up, and that was gonna be my first question. So,
Thank you, sir.
all right, let's go on the record. This is case number 2300071 UT. Today is January 19th, 2024. We are on day 3 in the matter of the tariffs, agreements, and forms proposed by qualifying utilities for the community solar program. So good morning, everybody. It is Friday. We are almost there. So first matter of business before we begin introducing evidence today is housekeeping. So Stephanie?
Thank you, sir. So yesterday, when I was cross-examining Mr. Sutledge, I realized that the way he was calculating the bill credit, as reflected in the attachments to his direct testimony, did not appear to track what the rate requires and how it operates. And if you recall, Mr. Sutledge explained if he calculated it according to the way the rate rider seems to indicate, I wouldn't like that number, it would be much higher, and so forth. And so thinking that through, an understanding that he calculated the minimum demand charge or the minimum bill charge differently than how the rate rider actually operates.
Okay, hold on. Let me just what's the this is a little different than housekeeping for me.
Yeah, I guess
What is the
I'm sorry.
gist of your request here?
Yes,
We're making argumentative statements on the record here, so.
Sure. Just for background, for my request is that I don't think the record contains an accurate reflection anywhere of what the solar bill credit would actually be if calculated pursuant to the terms of the actual rider. And so I was merely going to state the record is incomplete without knowing what those numbers are, and perhaps a bench request would be in order. And I don't want to sit here and make a bunch of argument other than to show you that I don't believe that PNM has calculated the bill credit based on the rider. And therefore, the record is devoid of what that calculation would look like.
Okay, PNM, any response to that?
I assume Mr. is saying that Mr. Sutledge's calculations isn't consistent with PNM's proposed rider? Or are you talking about the rules?
I'm talking about how rate rider 4B, the calculation of the minimum demand charge, basically, and I don't want to, get into too much merits, but it requires the greater of 4 options under the determination of total demand section in 4B, and PNM applied the lesser of those 4 options when
That's right. We applied the most conservative estimate of minimum demand to exclude from the TAR, therefore driving up the solar bill credit. That is our position. So we would not support filing something that I don't know that we would support filing what Missouri is asking, because that's certainly not our position. If the hearing examiner would like that as a bench request, of course, we will do so.
May I respond?
I'm gonna just make my determination now on this, because I'd like to get into our witnesses this morning. This really sounds like something that can be completed in briefing and response briefing. Ms. Sir, make sure to raise your point in your briefing argument. And
Thank you, Your Honor.
I'm sure PNM will respond to that.
Thank you.
Any other housekeeping before we begin with our witnesses today?
Mr. Examiner,
Yes, Ms. Hardy.
thank you. I wanted to advise you that SPS has determined we don't have questions for Mr. Desjardins, Mr. Farrell, or staff. So we are prepared to waive cross for those witnesses.
Okay, so you were the only party for Mr. Desjardins.
Mr. Hearing Examiner, there's one correction I was going to have him make in the record. Would you like me to call him for the purpose of making that correction, or I could do it myself? It's a typo that it leads to an incorrect web address in a footnote.
Okay,
So if you click-
that's fine. I'll let you do that one yourself. Let's just handle that after Mr. Barnes, but his presence as a witness won't be necessary. Then all parties have waived cross-examination.
Thank you.
And when we get to introduction of his testimony on the record, you can do that. If it's just something that simple, I'll let you do that correction yourself.
Is that good morning, Mr. Hearing Examiner and colleagues. My name is Marielle Nanasi. I just wanted to know if that is also the case, because I will tell my witness, Mr. Farrell. I believe that SPS was the only party who asked for cross-examination, and I could waive. If they have waived, then I could, and you don't have any questions for him, then I could call him up and tell him that he doesn't have to appear.
Yep, I was just going down my through my spreadsheet and see SPS is waived for Mr. Farrell. They were the only party. Mr. Farrell is excused as well.
Thank you so much. And thank SPS.
Okay, that'll shorten up our day today. So let's begin with CCSA. Please call your first witness.
Thank you, Mr. Hearing Examiner. CCSA calls Mr. Justin Barnes to the stand. And the witness is ready to be sworn in.
Mr. Barnes, would you raise your right hand? Do you solemnly swear or affirm the testimony you're about to give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Morning, Mr. Barnes.
Good morning.
Can you please state your name and spell your last name for the record?
My name is Justin Barnes, B-A-R-N-E-S.
Thank you. And by whom are you employed and in what capacity?
I am the president of EQ Research, LLC.
Okay. And do you have before you what's been marked as CCSA Exhibit 1, which is the direct testimony, which you pre-filed in this proceeding on November 13th of 2023?
I do.
Okay. And did you prepare or cause to be prepared this testimony?
I did.
And do you have any corrections to make?
I do. At page 92, at line 15, the word customers should be replaced with the word customer.
Okay, thank you. Mr. Hearing Examiner, I'm not sure if that I know it sounds like a somewhat minor thing, but you know, we did want to make clear that he's talking about a customer charge as opposed to a customer's charge. So I don't know if you need an errata on that or if this oral correction is sufficient.
And this oral correction is sufficient for purposes of that. That's fine.
Okay, thank you. And Mr. Barnes, if I were to ask you the same questions here today, would your answers be the same as what you have in CCSA Exhibit 1?
They would be.
Okay, I'd like to move for the admission of CCSA 1.
Yeah, let's go ahead and do Exhibit 2 as well, since that's an errata.
Okay. Mr. Barnes, do you have before you what's been marked as CCSA Exhibit 2?
I do.
And is that the errata that you filed to your direct testimony on December 4th, 2023?
That's correct.
Okay, and is the errata still relevant today?
I believe it is, yes.
Okay. I would move for the admission of Exhibit CCSA 1 and 2.
Okay, request is for CCSA Exhibits 1 and 2 to be admitted onto the record. Any objection? Hearing none, they are admitted.
Okay, and just to clarify, because I realize there's maybe a little logical flaw here, I asked you if the questions I asked you in CCSA 1, if I asked those to you today, if your answers would be the same, and you said yes. Is it correct that your answers would be the same subject to the errata in CCSA 2?
Yes, they would be.
Okay. And then do you have before you what's been marked as CCSA Exhibit 3, which is the rebuttal testimony, which you pre-filed on December 8th of 2023?
I do.
And was that prepared by you or under your supervision?
It was.
And if I were to ask you those same questions today, would your answers be the same?
Yes, they would.
Okay, I'd like to move for the admission of CCSA Exhibit 3.
Request is for CCSA Exhibit 3 to be admitted onto the record. Any objection? Hearing none, it is admitted.
Thank you, Mr. Hearing Examiner. One other matter that I wanted to ask you about, if you'll recall, on Wednesday, I had a conversation with Mr. Schiestel from EPE about certain energy information administration data regarding EPE's sales. And I indicated that we had thought we found a mathematical error, and I wanted to verify it with the EIA data. Mr. Schiestel was not able to confirm the EIA data. He said he wasn't familiar with it, and I think you directed us to have Mr. Barnes introduce that. So we did prepare an exhibit, not the spreadsheet, a PDF derived from those spreadsheets with specific references to where the data came from. And so we have that and are ready to introduce that if that's how you want to handle it.
Yes, can you go ahead and which exhibit is that labeled as?
It's labeled as CCSA Exhibit 28.
Okay, yeah, go ahead and introduce that with Mr. Barnes then, please, laying the foundation for it.
Okay. Mr. Barnes, do you have before you what's been marked as CCSA Exhibit 28?
Yes, I do.
And can you explain what that is?
It is a comparison of the sales and revenues numbers based on US EIA Form 861M for El Paso Electric for the year ending September 2023. These are total sales and total revenue. That is relevant for the purposes of calculating the 3% subsidization limit, those revenue numbers. And so that exhibit details monthly sales and revenues through September 2023 and shows a comparison between those and what Mr. Schiestel provided to CCSA as part of their response to CCSA 7-3. So it was an attachment.
Okay. At this point, I'll move for the admission of CCSA Exhibit 28.
Request is for CCSA Exhibit 28 to be admitted onto the record. Any objection?
Mr. Hearing Examiner, this is Mr. Goldberg with EPE. I don't know if Mr. Barnes said if he was the record custodian or if he prepared this document, since we just don't have any familiarity with it prior to this hearing.
Okay, I think it goes without saying that since the link is to another site, that he is not the preparer of it. But I agree, let's lay a slightly better foundation. Mr. Schlesinger, can you ask the witness how he arrived at this table, basically? Let's get a little better foundation on here.
Sure. Mr. Barnes, did you prepare this table here in Exhibit 28?
I did.
And where did you derive the data that you used to prepare this table?
I downloaded it from the online spreadsheets for EIA Form 861M, which I would say that the data, at least as I understand it, is reported by utilities to the US EIA in Form 861M, so it's a required form. I prepared this based on an excerpt of what amounts to very large spreadsheets that lists most utilities in the country and their monthly sales and revenue amounts. So this is just the excerpt of that, referring specifically to El Paso Electric, New Mexico.
Okay. And does Exhibit 28 show the source of your work?
It does. It contains the source, Form 861M, a link to the website where I downloaded it, and a note detailing exactly where within those spreadsheets I pulled the data from.
Okay. At this point, I'll remove for the admission of Exhibit CCSA 28.
Okay. Request is for CCSA Exhibit 28 to be admitted onto the record. Any objection?
No objection. Thank you, Mr. Hearing Examiner, Mr. Schlesinger.
Okay. It is admitted. Thank you.
Thank you, Mr. Hearing Examiner. Mr. Barnes is available for cross-examination.
Okay, and I believe I have, for Mr. Barnes, I believe I have SPS requested 45 minutes.
That's correct, Mr. Examiner.
Okay, proceed.
Thank you. Good morning, Mr. Barnes. Can you hear me?
Yes, I can. Sorry, I accidentally muted myself.
Okay, thank you. My name is Dana Hardy and I represent SPS. In this case, you're acting as an expert witness for the Coalition for Community Solar Access, correct?
That's right.
And in that capacity, are you generally familiar with CCSA?
Generally, I think so, yes.
CCSA's membership includes for-profit developers, doesn't it?
That's my general understanding.
Okay. And I'm going to show you a document that we've marked as SPS Exhibit 5. If I could share my screen, Mr. Examiner. It looks like I have that capability.
Give me 1 sec. I'll make you co-host. Okay, you should be able to screen share now.
Okay, can you see that?
Yes, I can.
Okay. And this is a page from CCSA's website. Are you familiar with this document at all?
I am not.
Okay. And I'll represent to you that it's a printout of their membership list. And this list includes large for-profit multinational companies, doesn't it? I can scroll through it if you'd like.
Objection, Your Honor. I don't believe that the proper foundation for this exhibit has been laid. Mr. Barnes stated that he's not familiar with it.
Well, I can ask some additional questions.
Yeah,
Mr.
I agree. I agree with the objection. Let's get that foundation in first.
Okay. Mr. Barnes, are you familiar with the members of CCSA?
I probably could not name really any of them specifically. I don't know who's a member and who's not.
Okay. And you haven't looked into that as part of your representation of CCSA as an expert?
No, I had no real need to.
Okay. But you agree with me that the members include large for-profit multinational companies?
Objection. Objection.
Basis of the objection.
Same objection, lacks foundation. Mr. Barnes just stated that he wasn't familiar with this document. He's not familiar with who the specific members of CCSA are. So I don't believe he can answer questions about whether they're for-profit or nonprofit or anything else.
Well, if I can respond, I think he already did. I think he said he was generally familiar with the, he agreed with me previously. I was just restating his prior testimony. He agreed with me that the members include large for-profit multinational companies.
Okay, let's move along with the line of questioning, though, Ms. Hardy. I mean, I understand the argument. So let's proceed with the questioning. But to the extent that he is not familiar with this document, I'd like us to move along.
Okay, sure. I'll move along. Mr. Barnes, is it your testimony that companies that are members of CCSA would be unable to obtain financing for New Mexico community solar facilities without subsidies or other measures that favor developers and subscribers?
Without subsidies, meaning subsidies from whom?
From other customers. And specifically, I can point you to your direct testimony at page 40, lines 15 through 23.
If you'll give me a moment.
Sure.
Page 40, you said?
Yes. And really, I'm looking here at lines 20 through 23, where you state that absent a small amount of permitted subsidization, the utilities proposals would result in effective subscriber credit rates, and you give a range. And you state that those rates would likely be insufficient to support the creation and financing of community solar facilities, making them inaccessible as a result. Was that your testimony?
It is, but I emphasize that is based on the utilities definition of what constitutes a subsidy, not necessarily what is reasonable from the standpoint of long-term evaluation of community solar benefits. So,
and I understand. Are you finished?
I am.
Okay, thank you. I understand your position, but my question here is really whether it's your opinion that companies that are members of CCSA that are for-profit companies would be unable to obtain financing absent subsidization from other customers.
Again, based on the utilities definition of subsidization, which would place the effective value of a community solar subscription at 3 to 4 cents per kilowatt hour, I don't think that is a financeable value proposition for any company to offer, frankly.
And financing status was part of the scoring for the projects, wasn't it? Are you aware of that?
I believe it was.
Is it your opinion that it's the commission's responsibility to make projects profitable for developers and subscribers, even if they aren't economic?
I believe it's the commission's responsibility to properly implement the Community Solar Act. And beyond that, I can't really, I don't think it's it is the commission's responsibility to implement the Community Solar Act. The Community Solar Act potentially allows for some level of subsidization, and therefore the commission's responsibility is to determine what subsidization, if any, is appropriate.
Let's talk some about the bill credit mechanisms. Whatever the commission decides as to the calculation of the value of the output of the community solar facilities is not necessarily going to be what subscribers receive. Is that correct?
That's right. I mean, all of the subscriber rates are different, and presumably the value would be a single number.
And that number would be determined by the project developers. Is that correct?
I'm sorry, I'm not following you. Which number would be determined by the project developer?
Well, the for-profit project developers will be running the projects to make a profit themselves, correct?
Presumably, yes.
So the value customers will receive is up to the developer, not just the commission or the utility, correct?
Yeah, I suppose you could say yes, it involves all parties because, customers are being provided a credit by the utility at a certain value and are paying to receive that credit to community solar subscriber organizations at a certain rate to receive that.
So the developer plays a role, not just the commission or the utility.
Yes.
Let's talk for a minute about the environmental attributes of community solar that you discuss in your testimony. And I can point you to that when I get to it. But you're aware that New Mexico has a renewable portfolio standard, correct?
I am.
And the statute, the Renewable Energy Act, includes a definition of the term renewable energy certificate, doesn't it?
I presume it does. I don't know the specific definition.
Renewable energy certificates have a discernible value, correct?
Yeah, they do.
And the definition includes the environmental attributes from 1 megawatt of electricity generated from renewable energy. Is that correct?
Again, I don't have the definition in front of me. It sounds like a reasonable definition for a REC, though.
Okay. Is that it would be your understanding that the REC represents the environmental attributes of the electricity that's been generated, correct?
That is typically the case, yes.
Okay. And under the Community Solar Act, the utility hosting the community solar project receives the environmental attributes, including the renewable energy certificates from the project, correct?
That's my understanding, yes.
And if you can look at your direct testimony at page 28. And I'm looking at lines 13 and 14.
Reading RPS compliance and environmental compliance.
Correct. So your testimony states that the community solar project should, in the long term, be paid for what you refer to as RPS compliance and environmental compliance, correct?
I'm sorry, could you repeat that?
Your testimony states here that the community solar project should, in the long term, be paid for both RPS compliance and environmental compliance.
Well, yeah, if the subscriber credit value eventually became tethered to essentially kind of the value of community solar, yes, they should be compensated for both RPS compliance and environmental compliance if environmental compliance is not essentially kind of bound up within other components.
Okay. And your testimony also states, doesn't it, that you think the community solar project should, in the long term, be paid separately for greenhouse gas reduction, as well as high global warming potential gas reduction. Is that correct?
Those are benefit categories that can and should be considered.
And compensated?
In the future, in a future scenario where the subscriber credit is tied directly to the value of that community solar generation, yes.
So you're saying, aren't you, that non-subscribing customers in the utility should buy the same thing from the project, being the environmental attributes, multiple times? First for the REC, the renewable energy certificate, second for the short-term environmental value, and third for the greenhouse gas reduction, high global warming potential gas reduction. Is that correct?
No, that's incorrect. Those are all value streams that can be defined discretely and should be counted so that they don't double count a given benefit, but they're not necessarily fully overlapping of one another, depending on all of the details of underlying environmental laws and what is embodied within, if you were to calculate a compliance value for greenhouse gases, you might do that based on, say, a cap and trade program, right? There would be a compliance value associated with that. There's also potentially a social value if you were to use a social value of carbon that's different and distinct from the compliance value. That's an example of how they can be differentiated. So I'm not saying that they should certainly, I'm not saying that you should double count benefits. I'm saying you should count them to the extent that they are discrete benefits different from one another, or
If
not.
they could be quantified as discrete benefits.
That's right.
And are you aware of case law and guidance prohibiting the double counting of environmental attributes?
I'm not specifically familiar with a lot of case law, but generally speaking, as a policy matter, you shouldn't double count benefits.
The Renewable Energy Act, which governs renewable portfolio requirements for utilities, does not allow utilities to recover additional charges from customers based on greenhouse gas reduction or high global warming potential gas reduction, does it?
I don't know.
Let's talk about the benefits of community solar that you discussed in your testimony. And I'm looking here at page 16 of your direct. You advocate that the subsidy determination should include compensation for societal benefits. Is that correct? Really, I'm looking at lines 5 and 6 here on page 16.
Those should be evaluated for sure.
And are you aware that the commission has distinguished between customer benefits and public interest benefits in other contexts?
I'm not familiar with specific determinations, but it doesn't surprise me that they might have had consideration of that.
The Community Solar Act does not provide for developers or subscribers to be paid for public interest benefits, does it?
Well, it provides for them to be paid a subscriber credit based on the retail rate. I think the calculation of benefits is kind of a very different thing that isn't really contemplated in any detail in the Community Solar Act.
In the Act's only public interest element.
Can you guys hear me? Because I did say
now
it.
I can.
Okay, sorry. I said objection before that answer came in, so.
Okay.
Sorry.
Okay, so yeah, I did not hear it on my end. I picked you up when you said, "Can you guys hear me?" So
Okay. I'm sorry. Don't know what happened, but I lost my chance, so thank you.
Mr. Barnes, isn't it correct that the Act's only public interest reference refers to permitting a subsidy up to the 3% threshold?
I'm sorry, could you repeat that question?
Sure, I can rephrase it. Isn't it true that the Community Solar Act's only specific reference to public interest relates to the discussion of a subsidy up to the 3% threshold?
I don't have the Community Solar Act in front of me right now. If you could furnish me with a copy, I could, potentially confirm that, but I can't without it.
Okay, that's okay. I don't need to do that. I'll move on. The legislature could have directed that developers or subscribers be paid for public interest contributions, couldn't it have?
I suppose the legislature could have done whatever it wanted to.
Is it your position in effect, well, actually, isn't it your position in effect that the value of societal benefits should be charged to the general pool of utility customers and transferred to solar developers and subscribers?
My position is that the Public Regulation Commission should consider the full suite of benefits when it evaluates, questions that surround whether or not the community solar program can expand, because without consideration of that full suite of benefits, then the contributions of community solar that the legislature and potentially the PRC would like to support would not be redeemed.
And if the commission considered the societal benefits that you're talking about in relation to subsidization, isn't it true in effect that the utilities' other customers would be paying the developers and subscribers for those societal benefits?
In a manner of speaking, they would also be redeeming those benefits because they are part of society, though. I expect the commission would, give due consideration to exactly how to balance that.
If it determined that there were societal benefits.
That's right.
In your direct testimony, you state that the Community Solar Act does not require that utilities be permitted to recover the full amount of lost revenue. Is that correct?
That's right.
Isn't it true that Section 62-16B-7B6 of the Community Solar Act prohibits utility subsidization of community solar costs?
It does, but that's not necessarily saying exactly the same thing as utilities are able to recover 100% of the lost margins from sales to community solar subscribers.
And you're not an attorney, correct?
That's correct.
And you're not offering any opinions regarding constitutional law and takings, are you?
No, I'm not.
And you're aware, aren't you, that SPS charges its customers under commission-approved rates?
I am.
Let's talk for a few minutes about the aggregate retail rate versus the total aggregate retail rate. And you discuss in your direct testimony statutory construction and interpretation, don't you?
I'm not sure if I would phrase it that way. I believe I was discussing logic.
And you're discussing the Community Solar Act's use of the terms aggregate retail rate versus total aggregate retail rate, correct?
Right. Insofar as total aggregate retail rate is a specified definition within the Community Solar Act, whereas aggregate retail rate is not defined.
And do you have any familiarity with New Mexico's canons of statutory construction?
I do not.
Let's talk about the application of the 3% subsidy cap that you discuss in your testimony. It's your proposal, isn't it, that legacy customers within the 3% threshold would not be subject to additional charges for any subsidy in excess of that threshold that would be recovered from post-cap subscribers. Is that correct?
That's right.
Your recommended approach would eventually have the effect of later subscribers having a lower net compensation for their subscription energy, correct?
Potentially, depending on the specific valuation of community solar generation, that could potentially be the case.
And should that occur, isn't it true that CCA could take the position at that point that the compensation scheme is inhibiting growth of the program and that the subsidy cap should be lifted or changed?
Objection.
Basis of the objection?
Calls for speculation.
Okay, to the extent that the witness is answering strictly in his opinion, I'll allow the question. Witness can answer.
I suppose CCSA could take any position it wanted at some indeterminate point in the future. I don't know that they would or would not, though.
Thank you. With respect to your discussion of uniformity among utilities, it's your overarching recommendation, isn't it, that the programs be implemented with rules, protocols, and calculations that are structurally uniform in all material respects, correct?
That is correct.
Utilities have different non-uniform tariffs, don't they?
Well, yeah, certainly the language of some utilities is going to differ from the language that other utilities use.
And utilities have different executions of similar programs, don't they? Like energy efficiency programs?
I suspect that is the case.
And similarly situated customers served by different utilities generally have different rates, terms of service.
That there are differences in utility tariffs, yes, I understand that that is the case.
And your testimony asserts that uniformity is necessary to reasonably allow for the creation, financing, and accessibilities of community solar facilities, correct?
That's right. I mean, it's what makes a state level community solar program a state level program rather than 3 individual utility programs with different terms and conditions. It's what makes it a program, uniformity.
And the Community Solar Act, in section 62-16B-7B6 required uniform interconnection standards, correct?
That's my recollection, yes.
And it also required a uniform disclosure form, correct?
I don't recall that specific detail, but subject to check, yes.
And the legislature didn't require uniformity with respect to other aspects of the community solar programs, did it?
Again, I don't have the Community Solar Act in front of me, so I can't say specifically what it implied should be uniform, say, apart from those 2 examples you gave.
And the legislature could have included uniformity in other provisions if it intended to do that, correct?
I suppose, yes, it could have made an absolute express statement that everything be absolutely identical.
Thank you, Mr. Barnes. Those are all of my questions. Appreciate your time.
Thank you.
Okay, thank you. Next, I have next cross-examination. Let me just check time here. Is PNM.
Yeah, thank you, hearing examiner. Good morning, Mr. Barnes.
Good morning.
Can you hear me? Okay. My name is Tabria Twilliger. I'm appearing on behalf of PNM. Have you been listening to the hearing prior to today?
Unfortunately, I have not.
Let's talk about cost. In terms of utility costs related to implementation of the community solar program, would you say that your testimony recognizes 3 categories of cost? Bill credits, payments for unsubscribed energy, and administrative costs?
Those are the specifically referenced costs, I think, in my testimony.
But you would agree that there are other unidentified costs that utilities may incur regarding community solar implementation that are not necessarily included in those 3 buckets or categories?
I believe there are other potential categories of costs. Whether those, exist in practice, I can't speculate on that. But yes, there could be other categories of costs that utilities would experience.
And you referenced both the California Standard Practice Manual and the National Energy Screening Project National Standard Practice Manual. That's a lot of words. For purposes of an accepted protocol for determining when a subsidy exists for community solar. Isn't that right?
That's correct, both of those.
And wouldn't you agree that both of those manuals identify potential utility costs that it may incur, that a utility may incur outside of the 3 categories you listed in your testimony?
Yes, I do agree that those, those are much longer, much more detailed assessments of how to perform proper cost effectiveness analysis.
And in fact, on page 26 of your direct, you have a table that specifically, let me just flip to it real fast. It identifies potential costs. There are, if folks have a color copy, there's like orange or red dots that indicate there might be a cost to the utility, right?
Right. All of those categories are categorized as like typically a benefit, potentially could be a cost or benefit. That's the correct interpretation of the table, right?
To the extent that those costs are specifically identified by PNM and they directly relate to the implementation of community solar, you would agree that PNM should be able to recover those costs, right?
They should be considered in the context of a comprehensive cost benefit evaluation, yes.
So the cost should be considered even if they're netted by avoided cost or benefits, right?
Right. Cost benefit.
Okay. Did you participate in phase 1 of this proceeding?
I did not.
Did you review phase 1 stipulation and preparing your testimony for this phase of the proceeding?
I glanced at it, but I can't say I read it in any great detail.
Did you review the Community Solar Subscriber Organization agreement that was part of that stipulation or sections of it?
Again, I think I viewed it, but I don't know that I kind of retained a whole lot of that.
All right, since you viewed it, can I share my screen here, Examiner?
Sure. Give me 1 second. Okay, you should have that capability now.
Thank you. Can you see the screen? Oh, wait, not yet. Okay. Can you see the screen now?
I can.
Let me scroll up just so you have. Do you see that this is this proceeding? And this is the uncontested phase 1 stipulation.
I see that.
Does this look familiar to you based on your review or your limited review of this?
Yes, it does.
I'm just going to scroll down to where. I'm sorry. I'm not making anybody dizzy here. And you see that this is the Community Solar Subscriber Organization Agreement, Solar Facility. Is this the document you say you at least looked at for purposes of preparing your
Yes.
testimony?
It looks familiar.
Now we're on page A9 of this subscriber organization agreement. Did you review this T&D curtailment section for purposes of preparing your testimony?
Again, I believe I glanced at it. I'm not sure
Can you
I don't
read
know.
what's highlighted there? Is it large enough for you? Can you read
Yes,
it?
it's large enough.
Okay, can you read what's highlighted there? And then I'm going to ask you a question about it.
For the avoidance of doubt, a T&D
Oh,
curtailment.
I'm sorry, you don't have to read it into the record. I would like you to just read it to yourself.
Okay, give me 10 seconds. Okay, I've read it.
Thank you. So you would agree that the utilities and entering into a stipulation with CCSA and others agree to this term that says that curtailment will not be for economic purposes for community solar facilities. Is that essentially what that says?
That's what I read it to say, yes.
Or to accomplish least cost dispatch, right?
Right.
And uneconomic dispatch as a result of community solar is a cost that the utility may very well incur. Isn't that right?
That is a possibility.
And that cost is a subsidy, wouldn't you think?
It is a cost. Whether or not, when netted against other benefits, it produces a subsidy, that's a different question, but it is a cost to be considered in cost benefit analysis.
Okay, thank you. Hearing examiner, I would like to move for the admission of PNM Exhibit 12, which was the uncontested stipulation.
Okay, I'm not going to move it into evidence based upon his statement that he was not a participant in phase 1. I was looking through my administrative notice documents to see if we had a copy of that there. We have the order approving the uncontested phase one stipulation. So I'm actually, I'm going to take administrative notice of it, but I'm not going to put it on the record through this witness. I just, since he stated he wasn't part of phase one, I think it's odd to admit it under his testimony. But I'm going to take administrative notice of it, just like I did the order approving the uncontested phase one stipulation. Okay.
That's fair. I just noticed that it was not attached to the order, and that's why I put
That's what I was just checking. So,
but I would
we'll
prefer
take administrative notice of it, though.
Okay.
Thank you.
Thank you. I appreciate you doing it. All right. Mr. Barnes, would you agree it is difficult for P&M to determine the cost and the benefits associated with community solar until the location of the community solar facilities is confirmed and certain?
I would say it's difficult to do that with a large degree of precision.
You recommend to the commission, or you recommend that the commission rely on, and let me make sure I get the full word here, the National Standard Practice Manual, and for the court reporter's benefit, I'm going to start calling it the NSPM, for DERS, for guidance regarding benefit categories and a cost effectiveness calculation, right?
That's right.
Can you go? Well, I can actually just share my screen if it. I'm going to be looking at your exhibit JRB12 attached to your CSA exhibit 1. Can I share my screen? Do I have that capability? It looks like I still have that capability. May I share my screen here in Examiner?
Yes, you are still co-host right now.
Thank you. Okay, can you see that, Mr. Barnes?
I can.
You agree that's your exhibit JRB12?
Yes, I agree.
And in this manual, would you agree that it states that several of the benefits and cost of some DERs can vary significantly depending on when the DER operates and where it is located?
I agree that that's the case, yes.
Okay. And in fact, later in this NSPM, it states that's making the same point here, that they can vary, that cost and benefits can vary significantly depending on the location of the DERs, right?
Objection.
Basis of the objection?
Asked and answered.
That's fair. I did ask him already. I did ask him for a reference on a new page, to be fair, Mr. Schlesinger, but that's okay.
I think, yeah. Regardless, I see, that we're clarifying that, but asked and answered is correct.
And so I think in an earlier answer, I'm going to stop sharing here because I think we got that point. In an earlier answer, you said, and correct me if I'm wrong, and hopefully I don't draw an objection. I just want to clarify this for the record as I move on, that well, can you remind me when I asked you if it's going to be difficult for P&M to know the full spectrum of costs and the full spectrum of benefits for community solar until it knows with certainty where those facilities are? Can you remind me what your response was?
I believe I responded that it would be difficult to do with precision. And I think that there's certainly going to be some categories of benefits that are not necessarily dependent on location, whereas some others are. For instance, if you considered distribution benefits, those would obviously be dependent on location, whereas generation capacity benefits, not necessarily.
So this NSPM states that the benefits and costs can vary significantly depending on the location of the DERs. In your view, wouldn't it be better to wait till we know with certainty what the cost or where the community solar facilities will be with certainty, because they've interconnected and they're putting steel in the ground, before utilities are required to do an examination of the cost and benefits of community solar on their system?
Again, there are some benefits that exist regardless of location. And my recommendation, which I think is kind of consistent with what you just described, is that long-term evaluation take place, potentially in a couple years, or, at some future point when more is known about the community solar facilities that will exist on the system. My recommendation, though, was for the establishment of an interim methodology in order to kind of support predictability of the program overall. I didn't necessarily intend that, nor did I state that it would be the end-all be-all of benefits evaluation.
And could you remind me and point me to your interim methodology, what factors that's considering? Will you remind me where that's in your direct testimony?
I am attempting to scroll back up now. I was in the NSPM, so I'm about 300. There were definitely, I could just, certainly from memory, there were definitely, the interim methodology included energy-related costs, both fuel and non-fuel energy-related costs based on a combination of cost of service and, marginal fuel costs, line losses as necessary to gross up those amounts to reflect lower line losses on the system from generation sited in close proximity to load, potentially transmission benefits, potentially generation capacity benefits, as well as the value of RPS compliance. I believe those were all of the categories, although I'm still looking for the exact location in my testimony where that is.
I think it's probably page 28. If you're correct. And unfortunately, I'm going to have you go back to the NSPM now, or I can just share it. Did you find page 28? Would you confirm that's your interim? Sorry, go ahead.
Energy generation capacity, transmission capacity, line losses, RPS compliance, and environmental compliance to the extent not already included in one of the other benefit categories.
I'm going to have you go back to the NSPM, but I'm going to share my screen if you don't want to flip. You can read what's on the screen. You see that, Mr. Barnes?
I do.
You would see there, section 5.2 of your exhibit JRB 12, it says, generation costs and air emissions vary considerably over time depending on which power plant is on the margin. And this is specifically related to the DER operation, right?
That's right.
And it also says that transmission and or distribution capacity constraints, transmission or distribution capacity costs can vary significantly based on these temporal impacts can vary significantly depending on location. Is that right?
It does say that T&D impacts can vary based on location. That's right.
So even your interim list based on your own exhibit, well, never mind. I'll strike that question. Sharing. Okay. Let's talk about, you recommend that the ratepayer impact measure test, the REM test for the court reporter's benefit, should be used for purposes of determining non-subscriber impacts. Is that right?
That's right.
And the impacts to non-subscribers you're referencing are the 3% subsidy cap?
Well, specifically, yeah, the effect on rates, which is what the RIM test measures.
And you acknowledge that the RIM test typically designates lost revenue as a program cost under the rationale that lost revenues will ultimately be recovered, right?
That's correct.
But you would deviate from the RIM test for purposes of the community solar program and not recognize any lost revenue, right?
No, I wouldn't say I didn't recognize any lost revenue. What I simply said is that the avoided cost benefits can be netted against the lost revenue, which is effectively subscriber credits. And it remains within the commission's discretion to determine exactly what is recoverable and what is not recoverable.
Can you go to that Q&A where you discuss the RIM test for me? I think it's page 17 of your testimony.
I'm there. I'm sorry if you didn't hear me. I'm at page 17.
I heard you. I was just thinking about my question. So you recommend removing lost revenue from the consideration because you state that there's an equivalent assumption because program costs reflect the dollar value of the subscriber credits inclusive of loss-based revenue. That's your argument?
I'm sorry, could you repeat what is the question?
Sure. Let me see if I can ask it a little better. Your application of the RIM test would not consider lost revenue because you would consider it. Well, is that correct?
It would consider lost revenue.
In what way?
In terms of designating the cost of subscriber credits as a cost of the program. That is, by definition, lost revenue.
But we just discussed, did we not, Mr. Barnes, that, well, not just, we opened with this, that there might be additional utility costs outside of the three categories of costs you identified in your testimony, which were bill credits, unsubscribed energy, and administrative cost. So to the extent that there are costs outside of those three categories, doesn't your RIM test by methodology, by the way you interpret it, exclude the abilities or limit the abilities to utilities' ability to collect lost revenue?
It could potentially reduce the utilities' ability to recover lost revenue to the extent that the allowed recovery, that the commission's decision on what revenue recovery to allow is netted against future avoided costs. Now, the commission could do something else and say that full recovery of all lost revenues should be permitted. It should still consider those avoided cost benefits when thinking about the character of any subsidy that exists.
And correct me if I'm wrong, but the premise of your argument seems to be that the plain language of the Community Solar Act is focused on subsidies, not utility lost revenue. Is that your?
Yeah, it's focused on subsidies borne by non-subscribers.
Is subsidy defined?
I don't recall specifically whether subsidy is defined in the Community Solar Act. I don't believe it is.
Since it's not defined, subsidy could encompass utility loss revenues, right?
Yeah, and that's exactly what the RIM test does.
I know, but you're proposing to deviate from the RIM test, right?
On the basis that the Community Solar Act does not guarantee recovery of lost revenues. And let me give an example of where, say, the line between whether is a subsidy or not a subsidy becomes very blurred. Well,
I'm going to stop you, Mr. Barnes. Your counsel can ask you for that example on redirect. want to go to page 94 of CCSA Exhibit 1. I'm at the top there. Are you there?
I am.
You state at the top, and we're talking about the minimum monthly charges. Is that right in this section of your testimony?
Yeah.
And you purport to make a logical distinction for purposes of identifying what is a minimum monthly charge by stating the distinction should be whether it's a fixed monthly charge or whether it varies based on customer electricity usage, right?
That's what I say.
Do you know if PNM's minimum monthly demand charge varies at all based on usage?
It certainly does for some customers. I believe the specific language of the minimum monthly demand charge, as I recall it, is that it's either set based on a customer's on-peak demand, set based on a demand ratchet, or it's set at the customer's minimum contract capacity, which would be, I think, for one rate schedule, it's 50 kilowatts. For another, it's 500 kilowatts.
Does the absolute minimum demand vary based on customer usage?
Absolute minimum?
Let me just let's go over the tariff if we can. I'll pull it up and share it if it's okay with the hearing examiner. I'm going to pull up rate schedule 4B that was just approved as part of advice notice 616. You've reviewed PNM's rate schedules, is that right?
Yes, I have.
In particular, you've reviewed rate 4B.
I'm sorry, it's 4B. I reviewed both the large customer and general service customer.
So this is large power service, time of use rate. You see that?
I do.
Let's scroll down here. I want you to read, well, would you agree that under TUOU monthly charge, it states, absent any demand or consumption, the monthly minimum charge is the customer charge plus the total demand multiplied by the on-peak demand charge, right?
I agree that that's what that says.
Thank you. And if we go down to the calculation of demand, would you agree this is the determination of total demand?
Right, like I said, on peak, a demand ratchet, or the minimum demand defined in this schedule, or I think item D is like contract capacity.
Yeah, sorry, I didn't scroll down for you. But there is one of these options is a floor, right? That is the what I would call what the absolute, for lack of a better term, would be the absolute minimum that must be collected from the customer, right?
Right, there is some minimum. For most customers, it's still going to be based on their on-peak demand, though.
But subsection C is the minimum demand defined on the schedule would probably be the minimum amount that would be collected from customers. Would you agree?
Yeah, it would be based on, I think it's 500 kilowatts of demand.
Correct. All right, and going back up to the section, it says, absent any demand or consumption, the monthly minimum charge is the customer charge plus the total demand. So would you agree that that floor for minimum demand exists and does not vary based on customer electricity usage?
Yes, I agree that that's the case. I also would say that the Community Solar Act has another portion talking about what charges should be excluded, which specifically also states that the TAR should include all charges associated with a utility's generation in transmission. Sorry, I'm butchering it because I don't remember the language of the statute off the top of my head, but it is described in my testimony that there are essentially kind of two competing provisions for this definition of what should be excluded from TAR. And okay.
But you would agree with me that the commission has approved multiple rate schedules, multiple commercial rate schedules that have a minimum charge, which consists of minimum demand and customer charge. You would agree with that?
Yes, I agree that I agree that that is the case. The challenge is aligning that with the remainder of the discussion that is contained in the Community Solar Act of what should or should not be included in TAR.
And if the customer does not pay the customer charge and the minimum demand, they will not get service, right?
That's right.
Did you provide testimony regarding this indexing provision in the rules as it pertains to PNM's community solar bill credit, right?
I did.
Did you review Mr. Cray's testimony filed on behalf of CCSA and PNM's rate case, docket 22-00270 UT?
I did not.
Do you have an understanding of any of CCSA's positions in that rate case regarding banding and how the community solar bill credit should be addressed?
No, I do not actually.
So you understand, so do you have any sense that the commission approved PNM's class costs of service study and adjusted that based on a minimum and maximum band in order to mitigate the adverse impacts of a rate increase on residential customers?
I understand that rate mitigation was the purpose of banding. I haven't read the commission's final order in PNM's rate case.
Okay. And your proposal, your indexing proposal would essentially deviate from the commission's approved banding for PNM, would it not?
I don't know what the commission approved or did not approve in the rate case. I think I just said that.
Okay, well that's fair. So you don't know if you're asking the commission to treat community solar subscribers differently for purposes of calculation of the solar bill credit rate than those customers are treated if they're non-subscribers, if you don't understand the PNM's or the final order regarding banding in the rate case. Is that right?
What I know, so I mean, my direct testimony was filed before a final order was issued in PNM's rate case. Based on what the company had proposed and how it had modified its cost of service study in order to accomplish banding, I find that was a distortion of cost of service.
Sorry, go ahead.
A distortion of cost of service insofar, and one which would have effects on the community solar subscriber rate.
Okay, to the extent that the commission permitted what you would call, not PNM, a distortion of the cost of service for purposes of using banding to mitigate the rate impacts on residential customers, you are not proposing that the commission treat community solar subscribers differently than in terms of rates than they do non-subscribers, right?
I'm proposing that the commission consider the meaning of indexing and how I've discussed it as it relates to the designation of a community solar credit in this case.
If the bill credit rate, the result of your proposal would be that customers get a bill credit rate that does not reflect rates charged to other residential customers. Would that be discriminatory in your view?
Well, to be clear, the difference of opinion between PNM and myself is not the total rate, the total retail rate that residential or other rate classes of customers would pay under the mechanism. It's how that's functionalized. And from the standpoint of a standard residential rate customer, I don't think that functionalization makes any difference in the rate that residential customers would pay if banding was accomplished through an even distribution of banding across all functions, or if it's confined to the energy function as PNM proposed. Like, it wouldn't change, it wouldn't be discriminatory because the rate wouldn't change.
To the extent, since you did not review the commission's order, that the commission was very explicit as to how banding would be applied and proposed something different than what CCSA, or not proposed, ordered something different than what CCSA is proposing. Wouldn't you agree if the bill credit rate is calculated as a deviation from how the commission ordered banding in the rate case, you would be asking the commission to treat community solar subscribers differently for purposes of the bill credit rate than non-subscribers are treated, right?
If the commission had ordered that banding utilize banding only through modification of the energy related function, if that were the case, and you were to adopt my initial recommendation made before that determination, then there would be some difference, I suppose. I'm not sure exactly what it would be.
Okay, thank you, Mr. Barnes. That's all my questions.
Okay, thank you. Next, I have City of Las Cruces asked for 10 minutes.
Thank you, Mr. Hearing Examiner. Where are you? There you are. Good morning, Mr. Barnes. I'm Anastasia Stevens. I represent the City of Las Cruces. It's nice to meet you, sort of, in person. I have just a few questions for you. I'm going to take, sorry for that crashing noise of moving paper. I'm going to ask you to turn to page 17 of your direct testimony, which Ms. Terwigler was asking you about not too long ago. And let me see whether I've got it here. So at page 17, lines 10 through 13, oops, this keeps bouncing around. I'm sorry. I had it and then it got away from me. Big piece of testimony flies around. Okay. As your testimony at lines 10 through 13 is that the Community Solar Act does not require that utilities be permitted to recover the full amount of lost revenue. And you agree that nothing you've heard today has changed your position that the Community Solar Act does not mention or require recovery of lost revenues, correct?
I'm going to object on the basis this is a friendly cross.
No, it's not. It's not. If you, I'm sorry. Pardon me. I shouldn't have been.
I'm gonna allow the question just to the extent that she's basically asking if his testimony. I mean, Mr. Schlesinger has already asked if his testimony remains the same, but she's asking so I would consider that answered based upon that, but I'll allow the question.
Thank you. I could just move on to the next question. That was just preliminary. You agree that all of the methodologies proposed by the investor-owned utilities involved claimed lost revenues as their starting point for recovery. Is that right?
As well, I suppose as one element of it. There was administrative cost recovery and then the recovery of bill credit costs.
The bill credit cost recovery, but the lost revenue component is their starting point or their takeoff point. Is that right?
I think effectively that's a fair characterization.
And are you and it appears that you're endorsing that approach also with your RIM test. Is that correct?
I mean, I believe that the statute requires consideration of lost revenue in the way it discusses potential subsidies borne by non-subscribers. That's what dictates use of the RIM test, in my view.
And is it your position that lost revenue is always and necessarily a cost of the program?
Well, I think by definition, a subscriber bill credit that causes a customer to avoid paying a certain amount of cost to the utility, that's kind of the definition of lost revenue. Now, where I think it gets a little bit murkier is in situations where, say, a utility is over-earning for one reason or another. Is there really lost revenue associated with foregone revenue, or is that something different? It's hard to kind of call it lost revenue when a utility is earning above its rate of return.
And then on page, thank you, on page 17, lines 13 to 15, you testify that the proper way to think about this is to recognize that a subsidy or cost shift only exists to the extent that utility rate recovery from non-subscribers is authorized. My question to you is does the timing of rate recovery matter in that concept that you've got there? I think this may go to what you just said about.
Well, yeah. So the timing does matter, because let's say like we're in between rate cases and there is lost revenue. Well, other customers are unaffected by that because their rates don't change, at least until cost recovery is sought, whether that's, the recovery of a regulatory asset or, the realignment of cost of service determinants that cause a reallocation of revenue in order to kind of realign rates with, forecasted billing determinants.
So would the regulatory assets that the companies have proposed and that you appear to be to some extent supporting, would those regulatory assets constitute that transition to rate recovery contemporaneously or instantaneously?
Well, I mean, by definition, a regulatory asset would not be instantaneous recovery. It would be deferred recovery.
But it would be deferred, meaning it would the amounts would be starting to accrue contemporaneously or immediately, and the actual time of recovery is later. Is that right?
Right. The amounts would accrue as they accrue and then would be deferred into a later date for recovery.
So is it CCSA's position that these so-called lost revenues should be guaranteed recovery come a future rate case, just by virtue of the decision that the commission makes in this proceeding?
I anticipated, my specific recommendation was that utilities be permitted to record the cost of subscriber bill credits and accumulate a potential regulatory asset with the recoverable amount to be determined in their next rate cases. So it would still be a commission discretionary decision in their next rate cases as to what level of recovery to allow.
And let me see. If we return to page 52 to 54 of your direct testimony. And actually, I don't even necessarily need to read it because it's a fairly general question.
I'm there.
Your position is that any cost recovery should be for this type of cost should be recovered from future community solar subscribers, not from all community solar subscribers. Is that a fair summation?
For any costs, for any subsidy costs that are in excess of the 3% limit, my recommendation is that those only be recovered from future community solar customers rather than those customers that fall within the subsidy cap. Or probably more accurately, those projects that fall within the subsidy caps. You would have pre-cap projects and post-cap projects. Pre-cap subscribers, post-cap subscribers. Only post-cap subscribers would be subject to an additional charge to mitigate any subsidy.
And is that your idea? Do you have any basis in the Community Solar Act for making that distinction?
It's a mechanism I came up with to balance the need for certainty for existing customers, say within this existing tranche, as well as some of the, I guess, potential negative impacts in terms of market behavior that could arise if you were to allow projects far into the future to cause costs to be incurred by the initial tranche of projects.
So the answer to my question is there's nothing in the statute that specifically authorizes this treatment, correct?
Nothing that I'm aware of that says this is how it should be done. It is my own.
Okay, thank you. Those are my questions. Appreciate it.
Okay. We've got 10:26. Madam Court Reporter, how are you holding up? I have one more party that requested. Can we go for 10 more minutes?
Certainly.
Okay. Mr. Black, you requested 10 minutes.
Thank you, Hearing Examiner Mueller. Good morning, Mr. Barnes. How are you?
I'm doing well, thank you.
Good. I'm glad to hear that. You state in CCA Exhibit 1 that your professional career has been spent researching and analyzing numerous aspects of federal and state energy policy, spanning more than a decade. And you are now president of EQ Research. So I'm just laying a little bit of foundation for my questions. I'm not going to voir dire you. Don't be concerned. As part of the being a professional and an expert in this area of law, have you reviewed New Mexico's community solar statute?
I have. Like I said earlier, I don't have it right in front of me, but I have reviewed it, certainly.
All right, thank you. I'm going to refer now to CCSA Exhibit 3, which is your rebuttal testimony, page 29, beginning at line 3. And these are going to be questions to alert your counsel about whether a rooftop solar distributed generation customer should be allowed to participate in the community solar program.
Okay, I'm there.
Thank you. Here's the question. Does CCSA agree with staff's recommendation that net metered DG, or for our court reporter, distributed generation customers should be allowed to participate in SPS's community solar program?
I believe they should be able to participate in all of the utilities' community solar programs.
Okay, but my question was just, you still agree as to staff's recommendation that that they agree with that limitation on SPS's program, and we'll get to the other part in a sec.
If the question is, do I agree that SPS should allow NEM customers to participate?
Yes.
Yes, I do
Yes.
agree that that should be the case.
Thank you. Thank you. Now, does the PCSC still disagree with staff's position that it is acceptable that PNM and EPE exclude its net metered DG customers from their community solar programs?
I disagree with that, with staff's position on that front.
Okay. Well, does CCSE recommend that DG customers be limited in their participation in community solar by limiting the size of their subscriptions up to the amounts that do not exceed their energy needs?
Up to the amounts that do not exceed the energy that they would otherwise require from the utility. In other words, their net needs.
Yes, that's correct. That's what I intended to ask. Thank you so much for clarifying. Why?
Because they are, for one, retail customers that are not otherwise excluded by the Community Solar Act from participation in the program. But from a policy standpoint, there are plenty of customers that are not, when they install DG, able to accomplish a 100% load offset. Now, that might be because of roof constraints. It might be because of financial constraints. It could be because of any number of factors. And excluding them from the program, those customers that have a demonstrated interest in purchasing clean energy, I don't think is a good policy decision. Moreover, permanently excluding them from the program, is really, I think, contrary to their expectations when they bought DG, insofar as they could not have realized that when they bought a 50% offset system, that would effectively prevent them from being able to supply the remaining 50% through a future program like community solar. Had they known that there would be a community solar program, they might have just waited for that. But of course, they couldn't have known that.
What is CCA's FA's rationale for its recommendation to allow all customers, including DG customers, to access the benefits of solar energy under the community solar program in general?
Non-discrimination.
Okay, so I think you're referring to the New Mexico Public Utility Act, non-discrimination 6295 or something. I don't know.
I'm not referring to
I understand the concept. Are you talking about the general concept?
The general concept of saying you are arbitrarily excluded from this program.
Okay. All right. Okay, here we go. In your professional view, could there be some way for a DG customer to be offered some sort of financial incentive to step aside to allow other customers to reap the benefits of solar energy through the community solar program?
As in, are you asking whether there is a mechanism to make them voluntarily not participate? Is that the question?
Perhaps voluntarily could be. If they choose not to, then therefore they qualify for this rate credit or something.
I mean, anything is possible.
I'm just asking you to surmise, is there any way that a DG customer can be offered some kind of incentive to allow their neighbors, their friends, their family who do not have DG to participate in the benefits and reap the benefits of solar energy in their place?
I don't know any specific mechanism that would be permitted by New Mexico law, but I suppose in theory you could craft something like that if that was your intent.
Would that be a good thing from a policy standpoint?
I think I would have to think through all of the implications a little bit more in order to offer an opinion on that. Again,
in general, yes, I'm sorry, go ahead.
It's fully new to me, and I'd prefer not to state an opinion without thinking about it.
Of course, measured. Very nice. That's all my questions. Thank you.
Okay, thank you, Mr. Black. We're going to take a break. Mr. Schlesinger, I'm assuming you're going to have some redirect, correct?
Yes, Mr. Hearing Examiner.
Okay, we'll get to that when we get back from the break. Jacob, I know I lost a note here. I was going to ask a question of Mr. Barnes. Maybe you can help refresh my memory. I believe when you were cross-examining Mr. Shisto, we had a question regarding time periods, that why one number differed from his calculation. Do you recall that offhand?
Regarding time periods?
There was a conflict as to why Mr. Barnes' number was different than the number proffered by that witness. And the witness proffered that I don't know what time period was used.
Yes, I understand now.
Okay. So unfortunately, I lost my note on that. During the break, I'll try to remember, but I did want to ask Mr. Barnes that question. If you can handle that in redirect, that would save me the trouble. Just confirming what time period was used by Mr. Barnes. Let's take a break. We'll come back. I've got 10:36. We're actually a little ahead of schedule. Why don't we take a 15-minute or 14-minute break? We'll come back at 10:50, starting with redirect.
Mr. Hearing Examiner, may I just ask what you're thinking about for the future of our day before you take that break? I'm trying to plan. So I'm just wondering, because if you don't mind discussing this, what I see is that after the conclusion of Mr. Barnes, Mr. Desjardins is not being cross-examined. I understand that REI, has to put his testimony into the record, and then, and then Ms. Laroque goes, and then then Mr. Farrell's not going and Mr. Naughton's not going. Does that mean we're going to go to Mr. Dunn this morning, or is he going to be for this afternoon no matter what?
I still plan him for this afternoon. We've got roughly an hour and 25 minutes requested for him, so I still plan on him going in the afternoon.
Okay.
So we should have a nice short afternoon.
Thank you so much for letting me know. Appreciate that.
Okay. All right, let's go on break. Let's go until I'll be back at 10:52. Let's take the full time here. Okay. Thanks, everyone. Okay, I have 10:53 on my phone, so let's get everyone back. Madam Court Reporter, are you all set? Okay. Let's resume. Mr. Schlesinger, redirect.
Thank you, Mr. Hearing Examiner. Before I get into the redirect, I did want to address the question that you posed to me earlier about the inconsistency between the EPE witness and Mr. Barnes and the time periods that were used. I just wanted to clarify that I believe we've already cleaned that up. That was the hearing exhibit 28 that we got admitted at the beginning of Mr. Barnes's testimony this morning. And the timing issue that you're thinking about is over what time period they looked at the revenues of EPE. Their numbers didn't match up. Their sales numbers didn't match up. And when Mr. Barnes investigated that, he believes that potentially Mr. Schiestl failed to look at 12 months of data, and potentially he looked at 9 months of data. That was the point I was trying to get at with Mr. Schiestl, and I believe that that has been addressed through hearing exhibit 28. So I can move on to redirect then, unless you have additional
Yeah,
questions.
just give me 1 second to review that. Okay, so hearing exhibit and the numbers that were used by him incorporated month 10 through 12 of 2022 through month 9 of 2023. Okay, thank you.
Okay, shall I proceed?
Yeah, please proceed with redirect.
Okay, thank you. Mr. Barnes, can you hear me?
I sure can.
Okay, great. All right, so first I'd like to talk about a topic that you discussed with the attorney for SPS regarding the bill credit and the amount of control that a community solar developer has over the value of a community solar subscription. Do you recall that conversation?
I do.
And the attorney for SPS sort of indicated, well, sorry, let me just ask my question. Are you aware of any specific commitments that community solar developers may have made in the acquisition process?
Yeah. The Community Solar Act in section 573(12)E required community solar facility bids to include a commitment to supplement the community solar bill credit for any low-income subscriber for a minimum of 5 years by including effectively, you know, a certain amount of savings. So therefore, you know, for those bid commitments, you know, those amounts are already like locked in. And, you know, any changes that occur to, you know, say the community solar credit or other things that cause an additional cost to subscribers are obviously going to affect those without the ability of subscriber organizations to kind of reprice.
Okay, and I believe you referred to statute, but isn't it correct that that commitment's actually part of the rules?
I'm sorry, yeah, that's right. I should have said rules.
Okay, thank you. Okay, moving on. You also had a conversation with the attorney for SPS where she asked you about a number of the benefit categories and asked you multiple questions about whether or not community subscribers should be paid or compensated for those benefits. Do you recall that conversation?
I do.
Are you suggesting that the bill credit should include an explicit compensation for those potential future avoided costs or benefits?
No, at least not right now. I mean, the current credit is set by statute at the total aggregate retail rate minus certain excluded charges. So that kind of whole discussion of community solar benefits at present is really for the purposes of defining what constitutes a subsidy and what doesn't.
And it's your opinion that all reasonable costs and all reasonable benefits should be calculated or considered as part of that determination of whether or not a subsidy exists.
That's right. Or in, or so to speak, in the calculation of any subsidy to the extent it does exist.
Okay. Okay, thank you. Moving on to your discussion with the attorney for PNM. Again, you had a conversation about the values of various potential benefits. Do you recall that?
I do.
Are you asking the commission to adopt? Oh, I'm sorry. And part of that conversation had to do with the location of community solar and whether we need to know that before calculating those benefits, right?
I recall that line of questioning.
Okay. Are you asking the commission right now to adopt specific values for calculating those benefits?
No, my recommendation is that the commission adopt an interim methodology that considers all of the values identified in my testimony. The determination of the specific values in terms of dollars and cents, can be made at a later date, presumably in utility rate cases. That kind of gives us a little bit more time to determine exactly what those values are.
Okay, thank you. And then you also had a conversation with the attorney for PNM about lost revenues and whether those are always a cost that should be considered. Do you recall that?
I do.
Can you explain when lost revenues might be properly excluded or disallowed by the commission?
Well, let's say, for example, that a utility is over-earning. Well, presumably that means that they probably don't come in for a new rate case, but perhaps they do. Or alternatively, if you were to guarantee the recovery of all historic bill credit issuances, that could push a utility from, say, under-earning to over-earning. And I think that raises the question as to whether recovery of absolutely all lost revenue is reasonable, because, is it good policy to establish a system under which there is guaranteed recovery that guarantees that a utility will over-earn, or at least creates that likelihood? So, I don't think you can consider lost revenues that, if recovered, would cause a utility to over-earn to be really lost revenues at all, because in reality, they haven't really been lost. They've just been foregone.
Okay, thank you. You also had a discussion with the attorney for PNM about minimum monthly demand charges and whether they're properly excluded from the bill credit. Do you recall that?
I do.
And I believe that you were asked a question about whether the customer would always be subject to those minimum demand charges if they triggered that part of the tariff. Do you recall that?
I do.
Can you explain what would happen if a customer continuously were to, is it possible that a customer who continuously uses less demand than their prior average, is it possible that they would move to a different rate class? And can you explain how that would impact whether or not that should be considered a minimum charge or not?
Action.
Basis of the objection?
This is outside the scope of my cross-examination.
Yeah, Mr. Schlesinger, can you repeat your question, please, just for clarity?
Sure. Ms. Terwilliger, I'm not sure if I'm saying that right. Thank you. Asked Mr. Barnes about, the minimum demand charge and when they would be subject to it. And so I'm pointing out, or I'm asking Mr. Barnes whether they're actually always subject to that.
Right. I'll allow the question.
I'm sorry, could you now repeat it? Because I've kind of lost track.
Sure. Do you think a customer who may trigger a minimum demand charge consistently will stay on that rate?
I think a rational customer would not, presumably there is a certain term that applies to any given rate schedule, and they would have to wait for that term to end if they were a new customer. But that large power customer would probably move to the general power schedule with a 50 kilowatt minimum demand if it failed to meet 500 kilowatts on a typical monthly basis.
Okay. All right, let me just check my notes one last quick time. Okay, thank you. I have no further questions.
Okay, thank you. Redirect is finished with this witness and witness is dismissed.
Thank you, Your Honor.
Let's take Mr. Goldberg. Sorry.
Mr. Hearing Examiner, just for the purposes of planning, EP is going to waive its time with CLC witness Ms. LaRoque. And I know that SPS was also considering it, but I don't know what they ultimately decided.
Examiner SPS is also willing to waive its questions for Ms. LaRoque.
Okay. City of Las Cruces, EP and SPS have indicated a willingness to waive cross-examination for Ms. LaRoque. Would you like me to introduce the testimony onto the record directly?
Mr. Hearing Examiner, there are a couple of corrections. Some of them are written and on the document that's in the Dropbox. They're not significant at all, but we were going to go through them. And I was going to also lead Ms. LaRoque to the points in her testimony where there have been subsequent developments. I think the record reflects those, but just to make it clear, and they have to do with the EPE rate case on remand and the status of the stay request in the community solar rule appeal, both of which have been covered already by other witnesses. So if you'd like to just put it on and go through that, or admit it with the acknowledgement that there have been a few colored, red marked changes.
Yeah.
And there have been a few references, also a reference to the there's a conditional language in one of her pieces of testimony that relate also to the recent order in case 23000086 UT. I don't know whether this is really, if you accept the record if you accept her testimony as where it stands when it was filed, it's not necessary to do anything. And if you would like clarifications on the record, we're prepared to do that. And I'm sure she's surprised and delighted not to have to answer questions from anybody other than me, potentially, or you.
Okay.
So it's up to you, really. It's like, I think that the record or other cases make all this stuff clear. This was filed, the testimony was filed, in the beginning of December or November, and these are just subsequent events.
Yeah. I've reviewed the direct testimony. I've seen the corrections. None of them to me are significant in nature. And any objection to admission of CLC Exhibit 1 onto the record by any parties as corrected? Hearing none, it is admitted.
Thank you.
Anastasia, to the extent that any testimony has changed, I'll go over this more this afternoon. But in my part of my briefing order will describe, requests due to the final order in the rate case. Has that changed testimony of any party? So if Ms. LaRoque wants to weigh in on that, I will certainly. That can be captured in briefing.
Right, because we weren't going to say anything, just point out that things had happened. Okay, thank you very much.
Her testimony is mid. She is no longer required to appear. I will now do the same for Mr. Desjardins. In Dropbox, I have relabeled the exhibit as REIA, excuse me, Exhibit 1. Any objections to that being admitted onto the record? Hearing none, it is admitted.
Mr. Hearing Examiner, how would you like me to offer the correction?
Give me 1 second. Let me pull that up.
Yeah, I saw it disappear from Dropbox and I was panicking over here and I see that.
Sorry, I renamed it just so because it didn't have the title on it. It's listed now in Dropbox as REIA Exhibit 1. So if you want to make those corrections on the record, please proceed.
Okay, on page 7 of 14, there is, and I'm scrolling to that now, a footnote. One that has a link to PNM's rate schedules, and it incorrectly includes the letter K. So if you take that link at footnote 1 and delete the K, that link is otherwise correct. It should be pnm.com/rates1, and it says pnmk.com/rates1.
Okay.
That's the only correction, Mr. Hearing Examiner.
Okay. Exhibit will be admitted as corrected with that correction. Thank you.
Thank you.
Okay, that being said, all right, let me just do some housekeeping. Then. Ms. Yee, I know we had discussed whether or not you actually wanted to introduce your witness or move to have the exhibits directly. Do you still have a preference?
I can I have 4 exhibits and I thought that we had admitted the testimony and errata of Dr. Naughton's testimony when he was excused, but it would be fine to just introduce.
Yeah, I think I gave you the option if you actually did want to call him today. I'm just asking for scheduling purposes.
Oh, it's not necessary.
Okay, thank you. So all we really have done then, all we'll have for this afternoon then is staff's witness, Christopher Dunn.
And hearing examiner.
Yes.
PNM is ready to waive its cross-examination for Mr. Dunn. Or is prepared to.
David, do you know if Mr. Dunn is available?
I can make him available. Let me have him, I'll give him a call.
Okay.
Mr. Hearing Examiner, we haven't admitted, while Mr. Black is on the phone, I'm wondering if we could admit Mr. Farrell's testimony. That's New Energy Economy Exhibit 1. And I'd like to move New Energy Economy Exhibit 1, the direct testimony of John Farrell, into the record.
Okay, the request is for NEE Exhibit 1 to be moved onto the record as the parties have waived cross-examination. It is admitted.
Thank you so much, sir.
There's Christopher. Miss E, you have your hand up, and let me do Miss E and then Mr. Goldberg.
All right, again, Mr. Hearing Examiner, I thought that NMPEC Exhibit 1 and 2 were admitted at the time that Mr. Naughton or Dr. Naughton was excused. And if I'm incorrect about that, I would like to move NMPEC Exhibits 1 and 2 into evidence.
Yeah. Madam Court Reporter, have we moved those into evidence? Sorry. Or I can do so just right now. Maybe that's more efficient.
Don't know, Your Honor. I would
Yeah.
have to look at that date and I don't have access to it.
That's
Wow.
fine. That's fine. Just for clarification then, NMPEC exhibits 1 and 2, as the parties have waived cross-examination time, are moved onto the record.
Mr. Hearing Examiner, and just so the record is clear, because we're talking about NMPEC's exhibits at this point, I would like to clarify that NMPEC exhibits 6, 7, and 8. So again, that's NMPEC exhibits 6, 7, and 8 were admitted without objection through PNM witness Michael Sedlich.
That is my understanding, that NMPEC's exhibits 6 through 8 are on the record.
Thank you.
Thank you. Mr. Goldberg.
EP is going to cede its time for Mr. Dunn as well.
Okay, thank you. Ms. Stevens?
The city cedes its will waive its cross-examination of Mr. Dunn also.
I'm sorry, does or does not?
Does. I'm looking at too many negatives here. I apologize. We waive Mr. Yeah.
Okay, so I believe the only party left then is SPS.
Mr. Examiner, we also waive cross-examination for Mr. Dunn.
Okay. Parties have waived cross-examination time requested for Mr. Dunn. Mr. Black, would you just like me to put your exhibits 1 and 2 onto the record?
So moved.
Okay. Staff exhibit number 1 and number 2 containing Mr. Dunn's prepared and rebuttal testimony are moved onto the record as parties have waived cross-examination time.
Mr. Hearing Examiner?
That concludes our...
Mr. Hearing Examiner?
Yes, Mr. Black.
Staff also has exhibits 3 and 4. The 3 is the direct testimony of Naomi Velasquez, and 4 is her rebuttal testimony. I move that into the record.
Okay. Staff exhibit number 3 and 4 are admitted onto the record as parties had previously waived cross-examination time. All right, that considerably shortens our day up, everybody. I do want to take a look at briefing. I will have a briefing order. There are definitely some questions that I want answered as part of your briefing. Obviously, you are allowed to brief on any subject that you want as part of your briefs. But I would definitely have some additional questions that I would expect to be answered in those briefs. Let's talk about timing. Let me pull up the calendar here. Madam Court Reporter, you've had the 2.5 days. What would be your estimate that the transcript would be ready by?
I will get it done as soon as possible, but I am quite busy, so probably the regular time 2 weeks from today.
Okay.
I will try for earlier.
Okay. I expect these briefs are not going to be short by everybody. My contention then, rather than going by statutory language, would be to give everyone until February 29th. Or might as well make it March 1st at that point to do briefing by. Does that sound amenable to everybody? Any counter proposals? All right. My briefing order will then indicate that everyone will have until March 1st for their briefing order Any response briefs will be the statutory deadline then. And I'll get that order out first part of next week, so we're not waiting on it. Any other housekeeping that we need to take care of?
Mr. Hearing Examiner, I apologize for my ignorance on New Mexico procedure, but are there any restrictions on page limits for those briefs?
I believe NMAC does contain, Mr. Black, do you recall that number offhand?
For the briefings, for the response brief, no. I'm trying to pull it up on in our 1.2.
I don't believe NMAC does. Do we want to does anybody?
I don't think
feel
that-
the need to limit.
I don't think that there's a limit on briefs in New Mexico.
Yeah, I think we've only seen that in orders, not necessarily statutory. So if no one feels the requirement to limit, I'm not going to limit, because I know we have a lot to get through for this. Anastasia.
There's a page limit on exceptions, but not on briefs.
Right.
Examiners, because you guys have the capacity.
Yeah, like I said, I think I've seen this particular orders that have limited it, but it's not statutory in nature. So due to the amount of material that we do need to cover, I'm not going to post a limitation on it.
Thank you. Nevertheless, we will endeavor to be as brief as we can in our briefs.
Much appreciated. All right. Any other questions? All right. Want to thank everyone for sticking to your time requests and being professional with each other. It's always makes this time a lot more enjoyable for me. Other than that, thank you, everybody. Thank you, Madam Court Reporter. Do you have any further questions you need on your end?
I have one question, and that is every exhibit that's in Dropbox now in the form that I can attach it? I know there was some questions about Excel and PDF and.
I believe all the Excels were converted to PDFs. So you should be attaching the PDF versions.
Thank you.
Oh, Mr. Hearing Examiner?
Yes, Mr. Black.
I had a question as to the email address for our esteemed court reporter in case we need to contact her with, of course, copying you. So if that could be made available, I'd be grateful.
Yes, it's A. Hoyman, initial A, HOYMAN, at rtreporters.com.
Thank you.
Okay, thank you everybody for your participation, and we are adjourned.
Thank you. It was a
Thank you.
practice in front of you.
Thank you.